Hello and welcome. This is the Parity in Pay Ordinance on Demand video for the Office of Labor Standards Enforcement, OLSD, with the City and County of San Francisco. My name is Beverly Popak, and I'm a Supervising Compliance Officer at OLSD, and we're here to help you understand your labor requirements. Now, before we get started, we need you to understand and know that in the City and County of San Francisco, we have two major types of labor laws: citywide labor laws and contract labor laws. Citywide labor laws are required for all businesses who operate and have employees in the City and County of San Francisco. Contract labor laws are required for companies who have a contract with us, the city. And by us, the city, we are a large city and we have a lot of different departments. Now, this contract can be a contract to provide services for us, where we're paying the business to provide services, or to be a lease, where the business is renting a space, perhaps even a permit to operate. If you have a contract with the City and County of San Francisco, take a look and you will see all of the labor requirements per your contract. Now that you understand that, let's go into a brief history overview. In 2017, the San Francisco Board of Supervisors passed first the Parity in Pay Ordinance, and this is the citywide requirement of what we're talking about today. And second, a salary history ordinance, which is a contract requirement version of what we're talking about today. And then what happened in September 2025, the salary history ordinance, the contract requirement version, was repealed. And that brings us to today. What does this mean? This means that salary history ordinance, and this is the contract requirement, is not a contract requirement for contracts signed January 1st, 2026 or after. So if you're watching this video and you already have a contract signed prior to January 1st, 2026, yeah, there's a contract requirement. But if you're signing a contract with the city on January 1st, 2026 or after, there is no longer a contract requirement for salary history ordinance. Now, that is the contract requirement history and where we are today. Now, today we're going to spend the rest of our time on the Parity and Pay Ordinance, the citywide part that remains in effect, that's been enacted since 2017. Now, there are some similar laws. The state of California has a California Equal Pay Act, and other salary history bans are present in many other states and cities throughout the country. I think the takeaway here is that you have to understand each law, as they may be similar, but they have different provisions. And specifically for us today, we're only going to focus in the City and County of San Francisco, which is our Parity and Pay Ordinance. So let's understand who has to comply, who's covered under this particular requirement. So who's covered employer? Now, all employers required to be registered to do business in San Francisco are covered employers. And if you're not sure if you're required to register to do business in San Francisco, you should take a look at the San Francisco Treasurer and Tax Collector's website. Visit them at this URL here, and you can see whether or not you need to register your business. Now, once you understand that and you have to register and you're registered to do business and everything, let's take a look at what these key provisions are for the Parity and Pay. The Parity and Pay Ordinance bans employers, and that's any entity required to be registered to do business in the city, from considering current or past salary of an applicant in determining whether to hire the applicant or what salary to offer the applicant. Now, the ordinance also prohibits employers from One, asking applicants about their current or past salary, or two, disclosing the current or former employee's salary history without the employee's authorization unless the salary history is publicly available. So some other things to keep in mind during the process of perhaps hiring someone, an applicant may choose to share salary history information with you voluntarily and without prompting. If that is the case, if they do that, then the employer may consider that information in determining the salary to offer the applicant. I would note that, though, of course, in your notes, just in case there are any questions. The date, time, who said what, who was present, et cetera, et cetera. So some best practices. Ensure that all steps of the hiring process does not inquire about salary history, such as the job application. It was very common in the past where the job application has a little box or part where the applicant must state, um, their salary history. The next best practices involve everyone involved in inform everyone involved in the hiring process about the requirements under this Parity in Pay Ordinance. Now, you're great. You're watching this video. I thank you for it. But it's super important that if you have others that's going to be involved in the process of hiring someone, they need to understand the requirements of this law. Now, let's unpack this Parity in Pay Ordinance a little bit more by going through some frequently asked questions. So question number one, can I ask the applicant about their salary expectations? And the answer is yes. You can ask them about their expectations. You cannot ask them about their salary history. So there's a big difference there. Question number two, if the applicant tells me that they're making X amount of money and sends me this information, is this okay? Yes, this is okay if it's voluntarily done and it's without prompting, meaning you're not asking them to do this, of course. Now, question number two, if I'm a small business, do I have to comply with this law? Yes. Any entity required to be registered to do business in the city must comply with this law. And again, go to the Treasurer and Tax Collector's office's website to check and see all about that, whether or not you're required to register to do business. Question four, if the applicant's salary history is on the internet or posted in a place where I can see, is it okay to use this information? Answer is yes. If the information is publicly available, then yeah, you can use that information. Question number five, can employers retaliate against job applicants who do not disclose salary history information? And so the answer is no. You're not supposed to be asking about that, and definitely no, you cannot retaliate against any job applicants for refusing to disclose salary history. Question six, do employers have any notice requirements? And yes, the answer is yes. Employers must post the Parity in Pay notice, also known as our poster, in a visible place. We have an English, Spanish, Chinese, and Vietnamese version available on our website. You can just download and print these versions as necessary. And any language spoken by at least 5% of the employees, you need to have the notice in their language. So just take a look at our website for those versions. Question seven, can a company acquiring another company ask for incoming employee salaries and use that information to set the employee salaries? So the answer is yes. A company merging with or acquiring another company can ask for incoming salaries and use that information. So we've reached the end of this particular presentation and video. If there are any questions, you need any assistance, please feel free to contact the Parity and Pay unit. This is our phone number and our email address, and you could find resources, the legislation, and of course, the notices in multiple languages on our OLSC website under the Parity in Pay Ordinance section. Thank you again for joining us and watching this video.